we get updates on these developments from ICC Assistant to Counsel Attorney Kristina Conti. Welcome once again to the big story, Attorney. Good evening.
Yes, good evening. Good evening, ladies.
Now let's focus on the 500 that the court just approved to participate in the case. How were they chosen and how important are they?
Well, the ICC registry asked victims to submit their applications by August last year, 2025. We submitted as many as we can, including victims who had been very eager to participate since day one. But of course, there are others who would prefer to, at that point of the application, who would prefer to have seen the charges. If you recall, the charges were only disclosed to the public by September, right before the scheduled confirmation of charges hearing then. So at that point, we were kind of blind as to what exactly the scope of the charges were. So these 500, or they were in these 500 individuals submitted 300 application forms. These application forms were vetted. Initially, the charges included or mentioned 49 incidents. So from one point of view, it would appear as if all these crimes are consolidated, are concentrated on 49 incidents only. And initially, only 29 were considered, 29 individuals were considered to be part of the quote-unquote charges. Now that the court and the prosecutor, initially the prosecutor and then the court, clarified that, oh no, the 49 are only emblematic cases. They're only a sampling of the killings, and we're going to include thousands others. The rest of the applications, the rest of the applicants were admitted. And that is along particular guidelines. For example, one, could you show the relation of the killing of the incident to the war on drugs? Two, could you show that the killing happened in particularly Davao between 2011 until 2016 and nationwide from 2016 to 2019? And could you show the injury that was caused your family? And it was a wide range of injuries, which range from, of course, psychological trauma up to financial losses and setbacks. They were also asked to provide the names. First, they were asked to provide possible reparation mechanisms that they were willing to accept. And they were also asked at that time to provide the names of the legal representatives that they wanted to be appointed.
So this is indeed welcome news. But does this mean those others, it doesn't exclude others who haven't yet applied? Eventually, they can apply?
Yes, the application for victims' participation will go on until actually the end of trial. You could still sign up after, say, Duterte has been convicted. Because at that point, reparations will be issued or will be received by the victims. I do note, though, that there were 18 application forms that were excluded. But I would say they were excluded not because they were not victims of the war on drugs, not because they did not sustain injury, or not because they did not submit IDs. I mean, all of these mothers, all of these families were fantastic in their application forms. They submitted whatever they could. But there were a few who applied, but the killings happened outside of the scope, but still within the term of Duterte. If we remember, we left the ICC by 2019, March 16th. And so killings after that will not be qualified. And the victims of these deaths in the second half of Duterte's term would technically not be considered victims in this case.
So they can go to the state for redress eventually?
They could. That's one thing that we hope for, but there's another possibility that the ICC could consider collective reparations. And it's one thing that we're trying to figure out in this case, because the effects of the war on drugs are so massive that you cannot just encapsulate and say that, oh, here's some money that would be enough to repair your life. I mean, there were a lot of types of injury that were caused to victims. So we're hoping that the ICC also considers that, such as socioeconomic projects, such as community projects, memorialization, and the like.
All right, now let's go to the confirmation of charges hearing, which will begin on the 23rd. We expect this to run for several days, not just one day.
Yes, will go on for 4 days, but I think it would just be essentially it's 3 hours each day for 4 days. So essentially it's half a day if it were to be continuous. It's just that they needed to put in a lot of breaks to consider Duterte's condition. It seems as if he is not able to sit for long periods of time, or I guess to concentrate maybe for long periods of time. And so the hearings are scheduled so that there's 1 hour, we start 1 hour from 10 o'clock on the 23rd, we take a quick break, there's another session, and there's another session. And we have to stretch it out over 4 days. The third day will be a full day break on February 25th.
All right, Attorney, I wanted to ask you about the request of the defense to remove the 3 lawyers, the case manager, Ms. Nicolene, as well as attorneys Andres and Butuyan. Do you think this will be granted?
I'm sorry, but I cannot speak on this matter yet. But what I can tell you is that the lawyers will be able to submit their comments or observations as to this request. Maybe we can just wait for that and the final decision of the court. But what I can say is that this will not affect the February 23rd hearing. We will push on. We will have at the least the OPCV representative, Paulina Masida, stand in for the interests of the victims. And also, until there is a decision from the court, these lawyers and the full legal team, as soon as they are appointed, will represent victims in this case.
Any hitches still that you can anticipate that can derail the confirmation of charges hearing?
Force majeure. If there's a storm, if there's an act of God that would compel the ICC to postpone the hearing, that's the only thing so far now that I see. The denial of their request, of the defense request for leave to appeal the question on fitness to stand trial, that decision is critical because that would have essentially stalled the proceedings. If Duterte is unfit to stand trial, or maybe they raise it again, essentially the proceedings would have to be adjourned or stopped, again, to determine if he is fit to stand trial, if he's okay, etc. So at least there's kind of a certainty to this issue.
But the fact that his condition was taken into consideration, this means that he has not waived his right to appear.
I would say so. And from what I've heard, we're really expecting him live in person to appear before the court. Although, of course, there's still his option to appear via video link or video conferencing.
Attorney, just wanted to go back to Sean's question about the defense's request to revoke the designation and to disqualify the 3 Filipino lawyers. I know you can't go into the details of the request because a lot of the information was also redacted, but help us understand under what conditions can a party argue conflict of interest as well as impediment to representation?
All right, so in general terms, conflict of interest means that you have participated or you have coordinated and substantially coordinated with another party or have looked into the same issues within the same case. So essentially, nakausap mo, naka-coordinate mo yung kabila. And in this case, there are 3 parties. It's the prosecution, the defense, and the victims. So whichever party they would have coordinated with, that would constitute conflict of interest kung tatawid ka. also, it would also involve access to evidence or access to information. If you had access to information, you have the duty to disclose. And so I think that could be one matter also where you would be perceived to be biased. So ultimately, that's the point. They can claim conflict of interest, they can claim, etc. And the premise would be you are biased and you will not be impartial enough to fulfill your duties.
And do you think this is a legal strategy on the part of the defense? And would you say it's a delaying tactic, or do you think it won't have any bearing when it comes to the timeline of the proceedings?
Oh, this won't have a bearing on the timeline. We will proceed with February 23rd, as I said again. We could have just one legal representative if the request is granted. There's still Paulina Masida of the OPCV. But as of now, sans that decision from the court, we would have 3 legal representatives standing for the victims.
But how would the victims feel, attorney, if they will be represented by a different lawyer? Siyempre, mas okay din naman kung Pilipino ang magre-represent sa kanila. They speak the language, they understand what the victims went through. So what are the implications if ever iba yung magre-represent sa kanila here?
Well, we could look at it from a short-term and then a long-term perspective. In the short term, it's just for the hearing on February 23rd. But the victims actually have a little bit of anxiety and apprehension as regards representation because that's important to them. Yeah. They've done so many things just to make sure that they are heard. But we are taking the steps to make sure that whoever sits on the 23rd, they carry the voice of the victims for February 23rd. But in the long run, of course, we will still endeavor to make sure that the lawyers, victims, the common legal representatives of victims, is counsel of choice. And that's important for the victims. And as you've said it perfectly, it's logistical, cultural, psychological conditions. Of course, the lawyer must be someone, the victims, or the client, whoever, kung sino man dito sa situation na to, has to trust. It is a relationship based on trust.
Attorney, going back to the 500 additional victims that applied, like you said, there is no deadline, more could be added. So can we assume safely that we will not, and they will not take part yet in the February 23 confirmation of charges since we are still in the pre-trial phase? So dun pa sila sa actual trial phase papasok?
Oh, no. There are already qualified as participating victims now. The thing is, if you're a participating victim, you have the right to send in your views and concerns. Of course, through your lawyer. But that is a broad term. You can send in letters to the judge and to the judges or to the court and say, we don't like what's happening. It's views and concerns that actually, one, periodically are requested of the clients, of the victims, but also, on the other hand, which the clients themselves can volunteer at any stage of the proceedings. So it's important for the court to hear from all views, from all victims and all views. It's not that the legal representative of victims will screen the views and then put forward the most common, the modal, or the so-called centrist view. No. The duty of the legal representative of victims is to present all to the court.
All right, we thank you for talking to us, ICC Assistant to Counsel, Attorney Kristina Conti.